Hello, hello, lovely people. Thank you very much for your time. Thank you very much for your space. And thank you very much for the opportunity to allow us to come into your homes this Saturday afternoon to bring you the community and the law. My name is Oreku Frimpon. And today we have a very interesting question to answer. How does my child join me in the UK before he or she turns 18? Now, if the person is 18, is an adult, no, she is an adult, but before the age of 18, what can you decide for him or her? And when you'd want such a person to join you as a family here in the UK, how do you go about it? The law has what it says, and the community is probing into the law, and we're going the way of BWF Solicitors to give you that opportunity to have the answer. And again, we also be testing your knowledge on the information we give you. Now, today we have a very interesting nugget that we put out very early in the week, and we're going to look at that, have a discussion on that. My friend, my brother, and my learned friend, I should say, from BWF Solicitors, Lawyer Charles Asma, is once again with us to help us go through that. So, ladies and gentlemen, my brothers and sisters, we're live on BWTV, we're live on BW Radio, and I'll ask you to join us whilst we get into the deep end of it, the community and the law next. Hello, 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 lovely people. We're here in your homes, in your offices, at wherever you are. We're happy to be with you live on BWTV, BW Radio, and live on BWF Solicitors on the Facebook page, YouTube, and on LinkedIn as well. Of course, on all the social media platforms. And once you joined us, I want to say welcome to the show, welcome to our world, and welcome to our experience this afternoon as a community and the law. Now, today we have a very interesting question to answer. And the question is, how does my child join me before he or she turns 18? We are assuming that your child or your ward or your guardian, being a guardian to a guard, well, what's the word for it? Okay, whatever it is. You are a guardian to a young person and who would want to join you as a family here in the UK. How do you go about it? Today, I will be getting into some definitional issues as well. Every time we say child, every time we say a young person, what age are we looking at? What is the limit? And why do we have to make decisions on behalf of such people? Then again, what does the law say? What does the law provide that we can take advantage of? Or how do we go about things so we don't fall foul of the law? These are questions I would want us to get answers to when I get to introduce my friend, my brother, Lawyer Charles Asma, to give us that experience and the depth of knowledge. So invite somebody, like the page, send your comments to our comments page so that people would also enjoy the experience we'll be having between now and the next hour or so. My name once again is Olufipon, and I'm coming your way courtesy BWF Solicitors, our trusted partners when it comes to the law, nationality, family issues, when you want the interpretation of the UK law, the laws outside of the UK, especially in Ghana, and all the other bits. BWF solicitors are experts. They touch it and you are successful. They touch it and they tell you what to do, and you go through so easily, so well that you have so much relief and you don't spend too much money. That is the assurance BWF solicitors gives you. So let me pay homage to them, play the message, and I'll be right back.
This is our world. Here we are in our community. There are the laws. There are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community, is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us, speak to us, let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214 to 218 High Road at Seven Sisters in North London, N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner.
Okay, thank you very much for joining. As the trusted partners when it comes to the law, we're talking BWF Solicitors. BWF Solicitors, you can locate them on the 4th floor of the house, 214 to 218 Tottenham High Road, Seven Sisters, North London. Monday to Friday between 9:30 in the morning and 6 p.m. in the evening. You will find them there. Go and have that experience that people have had, and they are testifying to that. BWF Solicitor 0208 493 7340 or 077 127 61884. Now, ladies and gentlemen, I have this message from the Ghana High Commission I would want to give you. So please, let's say what they say. The High Commission of the Republic of Ghana in the UK wishes to inform the general public that effective 1st of February 2023, all applicants will be required to provide a self-addressed stamped special recorded delivery envelope with a tracking number when they submit the application, whether in person or by post. The envelope should be waterproof, strong, and big enough to carry the applicant's passport and supporting documents. They're asking us to note that the mission will not post the passports or documents back to you if you fail to attach the appropriate or required self-addressed envelope. So please be advised that processing time still remains the same. From the 1st of February, the Ghana High Commission is saying that all applicants will be required to provide a self-addressed, stamped, special recorded delivery envelope with a tracking number when they submit the application, whether in person or by post. The envelope should be waterproof, strong, and big enough to carry your passport and the supporting documents. So please take note of that and ensure you do that starting the 1st of February 2023. Now, back to the realm of BWF solicitors. On Monday, they dropped this piece of information, which I believe is of prime importance to all of you. The Brexit withdrawal agreement makes it clear that EU and non-EU family members of EU nationals who are status holders can only lose their rights in the circumstances set out in the withdrawal agreement, and the expiry of a status is not among them. In these circumstances, if an EU pre-settled status expires, the holder does not become illegal in the UK, even if they do not apply to have it renewed or for indefinite leave. Well, somebody will say, well, that's not what they have been telling us. But the law says that, and it's quoted from IMA for the Citizens' Right Agreement versus the SSHD. Um, I'll ask lawyer for that. Last time he told me and I forgot it. The European Commission intervening. Yeah, it's a case for 2022. So please be aware that the Brexit withdrawal agreement makes it clear that EU and non-EU family members of EU nationals who are status holders. So there are certain keywords there I would want us to really focus on. EU and non-EU family members of EU nationals who are status holders. Who will be the one having status? We'll get into that. Can only lose their rights in the circumstances set out in the withdrawal agreement. The withdrawal agreement, what is set out in there? One thing I would want to be so rest assured of is that expiry of a status is not part of those circumstances. Now, it goes on to say that in these circumstances, if an EU pre-settled status expires, the holder does not become illegal in the UK even if they do not apply to have it renewed or for indefinite leave. Well, with that, I will go into an area I am not well versed in. So I will at this point introduce my guest, my resource person, lawyer Charles Osma from BWF Solicitors. I know if it wasn't a bigger audience and we have the crowd, there will be claps and applause. So let's just ask, good afternoon.
Good afternoon, Robert.
Happy Saturday afternoon to you.
Happy Saturday to you too.
How are you doing?
We're doing well. By God's grace.
Lawyers, you and your technical jargons and, as Ghanaians would say, your big brother. What's happening here? Now, the nugget you gave us tells us about the withdrawal agreement, Brexit, which June, the 31st December 2020, we had to go out. June 2021, the deadline that was extended for us expired. Now, people know that in certain situations, I'll lose my bid because I have not renewed, things expired and the rest of it. Please, the ball is in your court now. This is what you gave us. Can you please ease it up for us?
Thank you very much. So before we offer our greetings, we go straight into the nugget. So the nugget for today is already echoed in one breath in the last couple of weeks, where we looked at the judgment of and referred to the ruling of one particular judge, and the key word we referred to was settled. Now, what the court in this ruling, so the case of R, and this is a civil society organization that supported somebody to go to court.
Okay.
And you can see that the person who took the matter to court ostensibly is a EU national or a EU family member.
Okay.
So this has nothing to do with Appendix FM. It's more to do with Appendix EU. So this ruling is for EU citizens and their family members who are in the UK and who have not been given permanent status, but pre-settled status or limited status.
Okay.
What it means is that per the meaning of the word or the visa you have, it's limited. So once it expires, you have to renew it.
Okay.
If you don't renew it, then you have become illegal. So that is the layman's understanding
of the
of
issue.
this. Pre-settled means not permanent, so you have to renew when it expires. But But what does the agreement itself mean? So we go to the root of the agreement itself, the whole idea of EU, where members are free, together with their family members, to move to and fro each other's state without restriction or obstruction.
Okay.
So if I were a family member of an EU, I would go with my family members to other places without restriction. If I'm a EU national, I will go to other places or other member states without restriction.
Mm-hmm.
Now there is Brexit. And we are saying that all those who came before the borderline, before the 31st of December 2020, you are in. However, if you are not given permanent stay and it is and what you have expires, you have to renew. So everybody is seeking to renew. What if I don't renew it?
Okay.
Does it mean it breaches the withdrawal agreement or it breaches Home Office policy?
Mm-hmm.
So there are 2 points here: Home Office policy to renew pre-settled status and withdrawal agreement to stay within that member state without restriction or interference.
Okay.
So what the ruling is saying is that if the agreement is what it is, from the spirit and letter of the Treaty of the European Union member states,
Mm-hmm.
if somebody entered a particular member state and the person is not restricted in any way,
Mm-hmm.
then why should the person be restricted in the UK if UK decides to move away, not the person deciding to move away?
It was UK that
UK
decided.
decides to move away.
Okay.
It doesn't. It does not. It shouldn't affect the treaty right of that EU citizen
Okay.
or family member. Therefore, if I'm in the UK and I'm given pre-settled within the policy, the Home Office policy, that you are given pre-settled, and if it expires, you have to renew. If I don't renew, does that break the withdrawal agreement? And the law, this is a case law. The case law says no, it does not break the withdrawal agreement, because the letter and spirit of the withdrawal agreement is that every citizen of a member state resident in the UK should not be restricted in any way, to the effect that we introduce policy to restrict that free movement.
Mm-hmm.
And their family members who have assumed right through should not also be restricted in any way. What it simply means that if somebody has pre-settled status and the person decides never to renew it, the person cannot be removed from the UK legally.
Pre-settled status.
If you have pre-settled status and it expires and you decide not to renew it or to convert it to settled status, if it's expired, it's expired, then you are illegal technically. But if you decide not to renew it and you are illegal, then you are not illegal within the meaning of the withdrawal agreement. It's only illegal within policy of the Home Office.
Okay.
But the question, which is higher? Is it the Home Office policy or the law passed by Parliament? And what the judgment is saying, that it is law passed by the judgment that takes precedent over the policy of the Home Office.
Right.
And therefore, to introduce that policy, which is incongruous to the law, then that policy itself is no good.
This is a ruling that needs to stand the test of time. The 14-day period for the Home Office to probably appeal against it and get it reviewed or whatever. Has that happened? If that has not happened, does it automatically confer that status on anybody that falls within that category?
Right. So normally we have case law, as we know, that with Akinsinya and all other cases, this case law. It only becomes challenging when somebody's rights, let's say, leave has expired, and Home Office says you have to leave the country.
Okay.
That is when we get to know whether this law actually works or not. At this stage, it's a High Court judgment, and therefore a powerful judgment. It's latest because it's 2022, and therefore it is good law as we speak now. There hasn't been any contrary ruling, and therefore it is what it is. However, has it been implemented. So we're looking at implementation of the decision of the court.
Yeah.
It only becomes implement when the Home Office takes steps to revise its policy to accommodate this ruling. And that revision of policy to accommodate the ruling hasn't happened yet. Therefore, I'm looking forward to somebody who has not renewed his or her pre-settled status. And the Home Office says that you don't have the right to remain, so leave. That is when we actually see the law working.
Then somebody will test
it. Exactly. Then we have
but in situations where people are in employment and the pre-settled status is expired, and the employer would go on to say, I can't give you employment. I can't continue to have you in my employment because your status has expired. This law is not being implemented. The guidelines have not been reviewed. What happens to such a person?
Very good. Because that is part of, that is the next point I was going to move to. Yes, the law says you can live in the UK, whether you choose to renew your pre-settled or not. Even if you don't have pre-settled, it cannot be removed. You can live because you are exercising your treaty rights. And prior to that, you didn't need anything to live in the UK. All you needed is to say, I'm here. And they give you concession that you are here with that blue card and what have you. But with this one, everybody has to go through the regularization. But the case law here is saying that even if you didn't do it, you still have the right to remain in the UK because you are exercising your treaty right as a member, citizen of a member state or family member of a citizen of a member state before the agreement within the free movement treaty. What if the person living in the UK without any restriction granted travels outside and is returning? Would that law work at the borders?
Question.
Because if you are returning, you need a visa to enter. You have to prove that you have residence. Are you going to use the case law to say that the case law says I don't really need anything, and even the one I got is really not necessary? No, because, and that is where the challenge will start from. Again, the case of employers, landlords for rental purposes, even banks.
Banks, yeah.
All these are enjoined by law to ensure that people who open accounts, people who rent, people who look for jobs have the right to do so. And they have the right, the duty they have is taken from the fact that the law says they must hold something. Now, there's another law which says that you don't really have to hold something. So those people are actually going to be in a dilemma. What do we actually do? Do we go by the court decision to give everybody amnesty, or we should go by the Home Office policy which says that check the card, whether it is not expired or not. Check the share code, go on the system to see what their status is. That's where the challenge is. And over the few weeks and months, I'm sure these conversations will come up. But I think it's good to preempt that the challenges ahead ought to be looked at. So the civil society organization, the advocacy groups that took the matter up, it's our duty again to ensure that we press upon the Secretary of State to review its policy guidance on this, so that it becomes obvious that employers cannot restrict people or force people to bring settled status if the pre-settled has expired, landlords and also banks. So it's a very good conversation, but I don't think the conversation will end today.
Well, whatever it is, I believe that if you have to do the right thing, you got to get to do it so that you don't fall into situations where you're so confused that you don't know what to do. The lawyers are there to help, and I would recommend that you go to BWF Solicitors when you have situations like that. BWF Solicitors, situated on the fourth floor of the Anna House, 7 Sisters, London E15 4NP. Travel by public transport. You take the Victoria line. Get off at Seven Sisters, exit number 2. It takes you to the front of the Anna House. Climb up to 4th floor, 9:30 to 6 p.m., Monday to Friday. BWF Solicitors are available to help you. Now, let me acknowledge my friends, my family, my crew, and all the wonderful people on the platform. Say, hey, good evening to all of you. Henry Vlad Norte. My friend, how are you? Long time. get in touch. Akwaba, he says. Then the next one we have Nanaya. Nanaya says, okay, Rebecca Mwako first. Good afternoon, dear brothers and sisters. Nanaya says, good afternoon, everybody. Henry Vladnote has a question, and I believe it's around the Ghana High Commission and the online and the passport bit. It says Ghana High Commission new online passport application is somehow, please, they should revert to the old system, if not make it simple. UK documents upload is so simple. Okay, we're making plans to get the Ghana High Commission to feature on the community and the law. So obviously, when we have the chance to bring them on, these questions will be addressed. But whatever it is, if you find any challenges and difficulty, what's the strategy I use these days with the Ghana High Commission is that on their website, I go and I use their automated chat, and that works magic. So try that. It will work magic for you as well. Henry, we'll bring in that later on. Boa, Naomi, good afternoon, lovely family. We have Naji, my lovely and affable class prefect. Thank you very much, Najimai. We need to have some conversation, so please keep in touch. J1 and Najimai, we have that one. Mercy, Frimpong, Gloria, Ansu, Nana Bafu, and all the wonderful people there. Samuel Miriku, I think there's a question. Okay, Samuel, we'll come to the question pretty soon. Let's get into some discussion first. Wumpini Adam, very much welcome. Nana Ya Chumwa Amwa, hello, watching from Ghana. Where in Ghana? Let me know. Is in Accra, Kumasi, or wherever. Tilly Juma is here. Then we have Tufor also on board. Was a message. Yes, Akimidates to 4 thumbs up. Thumbs up to you as well. Odeshiaba Nana Kweku May the day. That's a very strong name. Thank you very much. Ajimai and Ajimai, thank you for coming as well. Tilly, yes, Venture Tilly. And yes, we'll move on. So as we go on, I'll be bringing all the other ones as well to just welcome everybody there. A few questions there, Samuel Mukui. Yes, I'll be looking at your question, and later on we will answer that. Chiwo, yes. Salam bin Abdullah, thank you for watching. Gloria Ansu, Messi, Frimpong, Kofi Abuaji, and of course we are live on PAM TV with Pastor Augustine Abuaji, spreading the message into the Christian world as well. Pastor, thank you very much. Well, ladies and gentlemen, the question here is we're talking about getting your pre-settled status regularized to become settled status. We're talking about what the law is saying and a host of other things. Now, let me look at the situation where I have my child who is less than 18 years outside of the UK, and things have gone well for me. I've settled. I would want to bring my child or my children to come and join me. How do I do that? I want to look at this from the standpoint of where we're using UK immigration laws and if it does apply to EU laws as well. Well, Brexit is with us, and sometimes we get so confused whether those Brexit regulations and provisions are still working or not. That is the question I'm posing. How do I bring my young person or my child who is less than 18 to join me, or to join me before the person attains the age of 18? Lawyer Johnson Smith.
Thank you very much, Bragoku. So we take the opportunity to say good afternoon to viewers and listeners for making time with us this wonderful Saturday afternoon. We are going to learn once more, and today we're focusing on bringing your child from abroad to join you in the UK. There are so many rules within the immigration rules, adult, children, and all that. The ones that are so technical are the ones that concern children. And this is one of the technical rules that we'll be talking about. Because if you're applying for your wife, adult, or your husband, adult, of course, adult. It's not as difficult as bringing your child to the UK.
Why do they make it so?
Especially if you are not using the strength of you.
Okay.
If you are using the strength of you, then it's so easy. All you have to do is to prove that this is my child. And there are no age restriction. The only restriction is that if the child is over 21 years, prove that you continue to take care of them. Dependency. If the child is not over 21 years, prove that he or she is your child. And in you, there's no issue about definition of who a child is. And therefore, within EU, child means child, biological definition, or adopted definition. But within, once we move away from EU, and we are looking at standard immigration rules, child is a child within the definition of a child. So the question is, who is a child?
Yeah.
A child is somebody who is not yet 18 years old.
From day one
From day one
to 17 years, 364 days.
This, the person is a child. The moment a person turns 18, the person is deemed not to be a child, even though the person is still biologically a child, but legally not a child.
Okay.
So legal definition is that your child must not be 18 plus. If you want to rely on the strength of immigration rules to bring the child to the UK.
Okay.
Now that you've ticked that box, the next thing is to show who you are to the child. A parent or an adopted parent, still a parent. So we say a parent, either biological parent or adopted parent. If you are a biological parent, you have to prove that you are a biological parent. This means birth certificate, but more importantly, DNA. Because the DNA will take the argument of about birth certificate away and give you freedom.
Would the DNA be a recommendation
It is
or an obligation?
It is not an obligation, it is an opinion. So sometimes you present the birth certificate and they may put impediment in your way. And you end up having to do the DNA to take away such impediment that were first put in your way. Why do you go through double trouble if you can get it sorted once?
So you can preempt it
can
and
preempt
add further evidence
add the
to prove
DNA.
your parentage.
So that the DNA would just replace your birth certificate, the birth certificate of the child. If in one way or the other you think DNA is not ripe at this stage, then just use the birth certificate and deal with the challenge once it comes up later. That is one. That's biological child. What if I'm an adopted parent? So this is my adopted child. Then you cannot rely on birth certificate because adoption is not based on birth. So adoption is court document giving you parental responsibility over that child by operation of law through adoption process.
Okay.
So you should have then obtained the adoption document or certificate or order from court. So you cannot just go to a local assembly and get a document and say this is power that you can take care of. That is not order from court. So go through the process and get an order from court to show that the child has been adopted and this is the adopted parent of the child. And therefore, as an adopted parent, you have the same right of a biological parent so that a child can live with you wherever you are living in the world. So that is two ways of showing that you are the parent. The next thing is showing your status in the UK. Because if you don't have, you can't give.
Okay.
So you must have to be able to give to the child.
What kind of status can you give to anybody?
So you are in the UK and you have leave to remain, be it 2.5, be it indefinite, be it citizenship.
Okay.
So you have legal right to remain in the UK, such that the child can come and stand on your shoulders to live in the UK.
Okay.
So we have also proven that. So we are going through the tick boxes. The next thing is very, very important because these are checklists. Yes, I'm a mother, birth certificate. Yes, I'm a mother, adoption order. Yes, I live in the UK. I have 2.5. I have indefinite, or I have pre-settled. I have settled. I have a citizenship, my passport, blah blah blah. Yes, this, yes, that. But it goes further, and that's where it becomes technical. Paragraph 297 of Appendix FM to the immigration rules will tell you that bringing a child, you do not just prove what we have mentioned, but you must also prove that you, the parent, or both of you, usually one will bring the child. So the person bringing the child has sole responsibility over the child.
Okay.
Because it takes two, remember.
But then you have proven that this is my child, biologically or even through legal means. You have proven that this is my child. Why would I show sole responsibility when it's my child?
Right. Two reasons. One, the child is for two people, and
Right.
both must agree where the child must live. So one person cannot make a decision that I want the child to live with me. Then you have to prove that you are the sole maker in the life of the child to the point that you can make a decision as to, and this is a specific issue point where we are deciding where the child must live. So if you are making a decision to bring the child from where he or she lives to another place, then you must have the right to make that sole decision, don't you? Right. And to be able to have that right to make that sole decision, you must prove that you are the sole parent, so to speak. You are solely responsible for all decisions. If the responsibility is shared, then you need the other person to say yes. More often than not, the other person will say yes. I agree for my child to join mother or father abroad. But
if they've been through a bitter divorce?
so the question, how do I show sole responsibility? We'll come to that.
Okay.
Now, the rules or the authors of the rule preempted that it is easy for somebody to say that I consent for the child to go. Therefore, it's not a matter of consenting to allow the child to join the other parent. After all, we just want the child to live anywhere in the world. So if they are living there with you, then so be it. Let them continue. So that is locked within the law. So to be able to unlock that, you have to show that it's not a case of me getting consent, but it's a case that there's nobody
To take care of.
to take care of the child apart from myself under the circumstance.
But then that would be in a situation where record keeping is not so up to the point. In a situation where you find it difficult even locating the other partner or person to support you with the consent document or here and there, how do you prove that? Then it becomes impossible, really.
It is possible. It depends on how you approach it and when you actually decided to bring the child.
Okay.
Well, if this is your child, yes, we are not saying when you are relocating, you go with your child because it's not possible. But if this is your child, then presumption is that you visiting the child.
Okay.
So you must have evidence that you have not abandoned the child, you visit the child. Whenever you visit the child, you do what parents do, taking pictures with the child, showing concern in the life of the child, education of the child, and the care of the child. How do you show that you have interest in the education of the child? If you were living with a child in that home country, the teachers will be communicating with you. Then if you say that you are the person solely responsible and no decision is made without your consultation or without you being consulted, then the teacher should be dealing with you, isn't it?
Yeah.
And we are in a global village. So what are the emails showing that you've been engaging with teachers? Even WhatsApp messages with the teachers. Because you don't live there. Yeah, the child is living with a family member.
Right.
But you are interested in the education of the child. So look, over the past years, I have communication with the teacher or teachers of my child. at that school. In every school my child goes to, I take steps to engage with the teachers and I get to know what is happening.
Okay.
Anytime there is communication concerning my child, I receive email about it. These are email trends. Again, whenever there are school fees to be paid, I pay. So even the receipts are issued in my name. Whenever there's school trips to be made and they want parental consent, yes, there's somebody there who has to give consent that the child can go. But because they know that I'm the one in the life of the child, they even go to the extent of consulting me. And these are documents to show that I've been
Already
there.
done that. Yeah.
So, school, you have a lot to show. You don't wait till you are bringing the child tomorrow, then you put together today.
So you should start preparing early enough.
So it has
Because
to
you
be,
should
it
have
has
plans.
to be an idea that one day you bring your child. It's not even about because you want to bring your child. It's because you are a parent and you have concern for your child.
Okay.
So you have evidence to show. Child goes to hospital. Yes. Some of the decisions, medications and all that, they even consult you whether to do this or not to do. And you give your approval for the medication before they, so you have things from hospital, be it with the doctor, with the nurse, or even the person who is taking care of the child. Once they receive it, they forward it to you. Does that prove that you make the final decision, so they can't without your permission? Does that prove that? If we have all this to show, does that prove that?
Obviously, because I take all the major decisions.
So you are showing sole responsibility.
Okay.
Somebody will ask, oh, sole responsibility, what does it mean? How do I prove it? And that is why we are giving examples of how you can show. Child must eat, must clothe, must be sheltered. You send money. Evidence of the remittances you send. The child cannot show responsibility in terms of managing money. So it is not out of place to say that you send the money to the guardian you have put in place. And what is even the evidence that this arrangement is between you and that guardian? And for how long?
For how long, yeah.
And what has been the challenges the guardian has been going through to the point that they want you to come and to either come for your child or make a new arrangement. Over the period, you have even been buying time.
Okay. I see a situation where I've asked somebody to take care of my ward, and I rent a place for them to live in. If I have a tenancy agreement issued in my name, because I would have paid the rent advance and the rest of it I have to do back at home, would that be a good enough document to evidence my sole responsibility?
It is good. And because you are trying to link that piece of evidence to the decision to rent. It is not the person who says, okay, I've got a place, so come and pay. It's your decision to say that because of my child, I'm moving you to this place.
Okay.
So you are renting. But the procedures in place regarding tenancy arrangement in that country is such that it cannot be issued to a third party. It has to be issued in the name of the occupant. So it makes sense. But I would also want to see what happened. So it is not out of place to show something to suggest that before even a tenancy agreement was issued, you have emailed or sent message to the person that go and look for a place. The person has written to say, I found a place, it's going to cost maybe 10,000, whatever, for a period of 1 year. Should I go ahead? Go ahead. I will pay. You have sent the money, they've paid. And say, because of the arrangement, it is issued in my name. That's okay. Go ahead.
Pay.
Is it obvious that you are making such decision?
Yeah, it is, yeah.
So how do you prove it? That is how you go about it.
So obviously you have to show that the person is your child by birth or by adoption, and if by adoption you have documents to prove that. You have to prove that you make all the major decisions, that there's a sole responsibility bit that you are explaining. And to prove sole responsibility, these are the things you would need to go through. Let's say that the person who is taking care of your ward for you makes everything simple for you by writing a letter, supporting letter to say that since Adam's date, you have asked me to do X, Y, Z. I am happy to do that, but at a point, I think that I can't do it anymore. So if it is possible, pick up your word and go and live with the person. Would that be something to trigger any interest for somebody to say that, yes, you have full responsibility?
I would say it is something that will trigger your intention to remove the child or to bring your child to where you are living.
In that, you still have to prove all those bits for sole responsibility?
What? This is just showing that the child cannot live there anymore.
Okay.
But it is one piece of evidence, and there should be corroborative evidence. So you've mentioned that, and that is what most people do. Blah, 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 come and take your child. And even that, we look at the timing. We are making the application in January, and the letter triggering the decision to make the application in January was written in December.
Just a month away.
Does it appear as if it is preempted? Possibly. Because the person will not just tell you December is okay. It's not like you are living in Accra and the person is in Tema and it's okay, come and take your child and I'm bringing my child. This is traveling abroad, a lot of processes and rules. So it shouldn't take 1 month.
Right.
If the person is planning and they know that it will, of course, it's not also a case of punishing you to say that come and take the child, I'm fed up. They would have given you notice 6 months ago or a year ago. So if the person is saying that last time I told you, I reminded you, you say you will, I've been looking forward, you haven't done it. I'm sorry, at this stage, there's nothing I can do. If you don't come for the child, I will be left with no option than to send the child to maybe social welfare. You don't want your child to end like that. So you are taking steps. So if you receive that letter, depending on the circumstance, December, that means notices have been given and you have not even actioned it. So it's become so critical that you have to action it now. So if you are actioning it today, you are actioning it with reference to the notices that have previously been given you, which you ignored. Maybe you were not ready. So you can then make reference to that. It's not so crucial that my child leaves to join me because the person who is taking care of the child is not able to. The person has frequently been asking for me to do so, but I haven't. And now it's so critical that it will lead to this. It makes sense. Timing and exigency. So timing is very important. So proving, yes, you can use it to prove, but it's not just that. Also schooling, health, child, general upkeep and upbringing. Whenever you go there, what do you do with the child? Do you communicate with the child depending on the age of the child? These days we have WhatsApp as means of communication. Do you communicate with the child? And all. So it's not just to prove genuineness and subsistence of our marriage that we need WhatsApp. Depending on the age of the child may have a phone and therefore communicating with parents is not out of place. You can use it as evidence. Now, I think we've mentioned a lot of things that suggest to us that certain documents are needed.
Right.
That is proving that bit.
Just one bit, the sole responsibility.
Yes, the sole responsibility bit. And also to say that sometimes both parents may be in the country where the child ought to be born, let's say the UK, of course. If both parents are in the UK, then it is not a case of there are two parents and one is in that home country where the child is. So you need to show sole responsibility. If both are here, then you don't necessarily have to show sole responsibility. However, if both are here and they are not living together, then the one bringing should show sole responsibility for the child. Otherwise, why is the child not going to the other
Why
one?
the emphasis on sole responsibility?
Because you have to prove that, one, you are not imposing a will on the other person, the other parent, so to speak. Because it might not be the intention of the other parent for the child to be relocated.
Okay.
So you have to prove that you do not need anybody's permission to do so.
Does a child's opinion count here?
A child opinion counts, but you see, every child opinion will count. Every child will express the intention to join their parent. But the law, the rules are looking at the interest of the child. If the child is happier where they are living, then the law will say that it is not in the best interest of the child to be relocated. Even if the child says, I want to go to where my parents are, or where my father or mother is. And that is so, I will say that with a proviso, yes, the child's opinion counts. But when it comes to a child being brought up abroad, every child will want to come. So it's not a matter of what a child says.
Greener patches for the young person. Right.
So that's that. We'll come to the second link once we finish this.
Yeah, so I was going actually to go to the second link. Well, folks, if you have just joined us, we live on BW TV and BW Radio. Lawyer Charles Asma from BWF Solicitors is giving us tips as to how we can go about to bring our children to live with us before they turn 18. And one particular thing he has emphasized is the proving of sole responsibility. And that in itself, it's one albatross around the necks of so many people, because it's quite difficult sometimes to prove that. But if you have planned for that, if you have really purposed in your mind that you want to do that, you would have started preparations for all those things, and it will not take you by surprise. So whatever it is, just come along with us, follow the conversation, and we will get there. We're going to look at how to make the application itself. Now my T is on board and is saying, hello, great family. My greetings to all of you. Keep watching, like, comment, share. Danny Jr. is watching with us. Erica Sant is watching. Champoma, Lydia Biu, Cecilia Moy. Edward Dongote, you're also watching. Sambrako, thank you very much. Abdul Salam bin Abdullah, you have a question which I'll be posing to the lawyer very soon. Kevin Asamoah, good afternoon, lawyer Asma and Papa Oreku Aiko. Erajua, thank you very much. Esther Sapon, yes. Ademununkum, I mentioned your name. You can send in your comments and your questions. You can do that via text 07950422780, or you can call these two numbers. One is a landline, one is a mobile. The landline is 0208 123 1016, or the mobile 07399 208 468. Now, if you have a voice note and you want to send it via WhatsApp, and well, we can pick that from anywhere in the world. 07950422780. Lawyer, how do I make an application like that?
Right. So the beginning of the application should follow the documentation or gathering of your evidence.
Okay.
As I have already said, this is a technical application.
Right.
I would advise that, yes, I know a lot of us have become skilled and knowledgeable through our engagement with the community and the law program. But it is not everything that you can easily do with the knowledge and skill obtained from public engagement. Because this is one of the technical areas. You can make the application, but you can easily look at how, talking through responsibility, a lot of documents have come in.
Yeah.
So
and
you can
if
just
you are not even careful, you might not even think of adding any of the documents you have brought in.
All you care about is my child.
Yeah,
So let me bring my child.
Yeah.
But the decision maker is making the decision based on the law. So if you want to trick the decision maker, make sure that you've gotten everything right. Let them make a mistake and say that, hang on, you said X, Y, Z. I gave you X, Y, Z. Why have you not followed your own law? But if you don't, they will say, we wanted you to prove X, Y, Z. All you brought is that a letter from the person who is taking care of the child, and they say they can't do it anymore. but you have not proven anything over the period that you are even in the life of the child.
Okay.
Yes, yeah. So going back, if you have opportunity and you intend to bring the child under Appendix FM, take the chance to visit the child because you are building a case
Right.
for the application you intend to make. I say that children application under Appendix FM is a project. And you have to manage that project properly if you want a better outcome. So we move on to the second part so that we can just look at the process, because the process is not as serious as the documentation.
Okay. All right. I agree.
The second part limb is serious and compelling family circumstance.
No, hold on. Having gone through
So
the
responsibility.
trouble of proving that you're a parent and proving your responsibility, there has to be another thing you have to meet.
Yes. So there are points. So E, paragraph 297E, will tell you sole responsibility. What shows that you are the only person who can take care of the child. But if you are not the only person who can take care of the child, then why should you be allowed to bring the child? That's the sole responsibility argument. Now that you have proven that you are the only person, and therefore without you, the child has nobody to care for, the next question is, yes, we know that you are the only person, but whilst you are away, somebody is taking care of the child. What is so important that they have to come and join you here and not continue where they are. So that's the serious and compelling family situation or circumstance that makes the exclusion of the child from you from the UK, from coming to the UK, undesirable. In other words, why is this so important that if the child is not allowed to live where they are living, it will not be in the child's best interest? I simply conclude that what is so special that if the child doesn't come to you, they will die, quote unquote. You can see that it's a very high threshold point. How do I prove that if the child doesn't leave to join me, something terrible will happen? Then you have to prove that something terrible is imminent or is actual.
Right.
And what is imminent? Something that affects the life of the child. Could be rape. It could be gang involvement. It could be assault of a sort. It could be anything that may affect or harm the child. So if that is the case, the argument is that if I leave my child to continue living there and something happens, I will blame you.
Would emotional trauma be part? Emotional trauma, by my definition, what I mean is the child misses me so much. The child is so anxious to come to a parent who takes all the major decisions in his or her life. The child is so keen, even in the midst of friends who have parents and who have even had the opportunity of going on holiday abroad. In those conversations, the anxiety builds up and the rest of it. Could that be a very good circumstance for me to use to bring the child up?
Yes and no. I'll say it depends. And I'll give you two scenarios where this will play out. Scenario A, we are talking of Mr. A or Miss A who wants to bring the child. Miss A or Mr. A has lived in the UK, let's say for 10 years. All those 10 years, Miss A or Mr. A has never attempted to visit the home country where the child lives. 10 years, haven't gone back. Now, Miss A or Mr. A's argument is that my child is anxious to come see or live with me. My child is traumatized. My child is going through nightmare. My child, come on. You haven't even been there 10 years. The child hasn't seen you for 10 years.
But I communicate.
Yes, you communicate. The child hears your voice. And all of a sudden, after 10 years, they say that, oh, I'm dying because I can't live without my parent. Is it tenable? Not so sweet in a year.
But it's real.
Real, but we're talking about something that will give you more points. So that's one. So in this case, it wouldn't be the child saying that I'm anxious. It's a case of something that has happened that if you don't take immediate steps, it will affect the life of the child. Because if you have been away for 10 years, and by the time you were leaving, the child was 5 years, the child is now 15 years. So 15 years, they've survived. 10 years, they've survived. 14 years, they've survived. So why all of a sudden? Then there should be something compelling and serious. Do you agree? So that's one point. The second aspect where the anxiety and things emerging will be relevant, a parent who made application together with a child to join their husband. So recently, a case that we won at appeal. The mother was joining the husband, 2 children. The mother was granted. Remember, it's easy for a spouse to be granted. But the children were refused. And the argument is that one, no social responsibility and no compelling and serious family circumstance.
Meanwhile, the mother is taking care
Meanwhile,
of
the mother was taking care of the children.
is
and the mother
giving the permission to come in.
No, the mother was solely taking care of the children, single mother. But they raised argument because at the time of application, they couldn't prove that the mother was a single parent. So the argument we made to court is this. The children had the expectation that they were coming with their mother.
A reasonable expectation.
To live with their stepfather, who is now the father in their lives. They never had a father.
Right.
The children's expectation has been dashed by mere consideration of the law and refusal of the application. When the mother was leaving, the mother couldn't even explain to the children why she would leave and come and leave them behind. So the mother's excuse was that, don't worry, I will go, but I will make sure that you come and join me. Anytime the mother calls, the children ask him, Mommy, when are you coming? Mommy, you are deceiving us. Mama, you are a traitor. Mommy, you are a liar. The children are anxious. But the mom said, we are going together. The mom said, don't worry, I'll come for you.
I'll come for you. Yeah.
So the argument to court is, this is the situation. Is this not compelling and serious enough that if the child is not allowed to join the mother, it will affect the life of the child? Yes. Timing. And the timing.
And the strategy.
And the strategy.
Well, your questions and your concerns have started coming through. I've got one here. It says, I'm a British national and I would like to bring my grandson to the UK. Do I need to prove sole responsibility? Now, you're talking children, but this goes a step further down, a grandson. Is that possible?
Okay, so as I said, the conversation is within Appendix FM, immigration rules. And if you recall, or viewers and listeners will recall, prelude to the conversation was EU. And the difference between EU and Appendix FM. Appendix EU and Appendix FM are different. EU applications, you stand on the shoulders of the EU law and withdrawal agreement and Brexit provisions to bring all your children, and your children within the law include your grandchildren under EU provision. But in Appendix FM, your children are your biological children, unless they are your adopted children. So if you adopted a grandchild, then the person is your child by adoption. So if the person is your grandchild and you are bringing the person under Appendix FM, then you have to prove that you have adopted the child, not just bringing the child because they are your grandchildren.
Okay. Now, regarding parental responsibility, you mentioned Covenant Grace brings this one, says, what about if both parents are in the UK but divorced and the mother has sole parental responsibility? Mother has child custody order, but the father is undocumented. When a child arrives in the UK with definite leave, can the father who is undocumented, has no custody order, but now involved in the child's life in the UK through direct access, put in a successful application?
Okay.
Somebody's going to be
to
further benefits of that.
I mean, so what the person is asking is, can my child who has joined one parent in the UK be a source of my inspiration? Isn't it? So let's look at the genesis of the application.
Okay.
The person might have met the sole responsibility test.
Yeah.
And at that time, they were interested in bringing a child. So they made a very cogent argument that I'm the only one in the life of the child.
Right.
Presumably. Now they are saying that they are not the only one in the life of the child. Now that the child is here.
Circumstances change.
Good. So they have to prove circumstances have changed. Prior, this was the situation. Now, this is the situation, and has to be evidenced. So if this person who is in the life of the child, undocumented, whatever is, what we are saying, the person is a parent, must have parental responsibility. So if the person can prove that they have parental responsibility, then we are saying that they share the care of the child, and the person will come within direct access.
Okay.
But they have to prove it. Because before, everything was obvious that there's one parent.
Right.
And now it's not one parent as we thought. So there should be evidence to suggest that there is another parent who is involved in the care of the child.
You can send in your text.
I think that answers our sister's or brother's question.
Yeah. You can send in your text 07950422780 or call in on 073992084868 or 020812311016. Remember, we're doing this courtesy BWF Solicitors. We're live on BWTV and BW Radio and also on PAMTV. Someone who started with us, and he says, I'm an EU national with settled status in the UK. A month ago, I married my wife and wanted to bring her from Ghana to the UK. As an EU national, I would like to know if my wife has to write English exams.
Okay. And this is a good question. It's going to be a test question to address so many other questions that people may have, not necessarily asking them on the platform.
All right.
So let's look at the dates here. 2 dates have been mentioned. The first date is I am, and I'm taking it to today.
The present.
And the person also says 1 month ago. So I'm calculating 1 month ago to get today's date. And today's date is January 2023. 1 month ago, December 2022. The person says, I'm married 1 month ago. I'm a EU national.
Right.
So the person wants to know whether to make the application under EU provision or Appendix FM provisions. Because under Appendix FM provision, you need to prove the English language test.
Right.
Proficiency. But under Appendix EU, you don't need that. Because if you were to do the English, then that would be a restriction on your free movement as a family member of a EU national.
Right.
So that they remove that. Now, the person is EU. Should the application be under EU or be under FM? We'll go to the relevant. The relevant date is 31st of December 2020, 11 p.m. We can see that the person became a family member after the date, December 2022. They became
What if it's evidence that they had a prior arrangement to marry in Ghana?
Your word is arrangement. It is not marriage. Okay. But if they married within that relevant period, then they can say they married 1 month ago. Okay. I'm just going by the facts presented. So if the fact presented to us today is what it is, then we are saying that the person married after the date, and therefore they were not family members prior to the date and operations of Appendix U.
Okay.
Therefore, they cannot make application under Appendix U. For Appendix U applications, the family member should have been a family member before January 2021.
Okay.
This means the person can bring the wife or husband back under Appendix FM. Therefore, they'll have to meet the Appendix FM criteria, finance, English, and everything else.
Okay. 0739920848. Hello.
Hello. No, Broko. Good afternoon.
Good afternoon, boss. I'd say.
I want to.
Yeah, me on the Boko.
I'm a lawyer. Good afternoon.
Good afternoon, my brother.
Good. But so my question is that me no 10 year route no so. Oh, which is
Achama wale so kakra wa echicha.
And you can probably reposition yourself so we can get you clear.
okay. Yeah. Better.
Yeah, I think so, yeah.
But so me about na the power with 10 years soon or on the 10-year route no so. That's what I'm saying. You go renew no. Na you say akra no edi 9 and 10 to 10 years no. Obetumi apply for indefinite straight. And that's tell her
Apply for indefinite straight.
there be akra British.
Okay. And
I would
and 10 years.
10 years.
So you're asking if
Nine.
the mother can apply for indefinite straight depending on Akolana or
Yes,
your British citizen.
That's right. What I two
2.5 already. Oh, okay. So I think the question is can the child
Which
change
fast track, yeah.
fast track from 10-year route to 5-year route?
No.
Which are 2.5
Which fast track it to indefinite.
into indefinite.
Yeah. Right. Is it a life?
Yeah.
Director.
No.
Me pacho, what's the star? And that's a new panel. One am for will be start question how many 2.5 years and so you know the bay are British so.
Aye.
So it doesn't really matter so akola na enyi ya na so onyi ye. Or you're British. Until na maami no enya akwenya say, but man no taught. So what is here? To the first akola na enyi ni interest say taught no. You bet jump no am bottle. As I say, equal half, 2.5. Because say we be try 10 years. No?
Okay.
So try 10 years we are now for the wire application for indefinite leave to remain. Unless I say, or taught, and I say 2.5, no, or qualify, no, I switch about 5-year route, so depending on timing. So yes, I and you bet to me, and moving faster. But I know interest about 5 years, and also about 2.5, 2 times. But I don't know, ube here, sir, ube miti, nyoma bebre, ayana ayadin. Tina bebre no a, yadi omo call bus route no so no. Cause bus route no de, ayana buono requirement no ayadin. But we call training de, ayana ay serious. Enti, se wuntimi nko trainer, na watina bus no so. But what's the bus no so no kyerɛ sɛ wo akwanya a wode bɛfa bus no so akwanya no ne wo ba no a ɔyɛ British child no but the first akwala no nya 10 years no kyerɛ sɛ wobɛtumi ajump no wo akɔgye indefinite no nti ɔnwie ansa onya 10 years a na afei de wayɛ application for indefinite why
Okay. Anyway, thank you very much. 0739920848. Text 0795042278. Lawyer, we have a voice note. Let's pick that one up quickly. Or the voice note in the bio. This is yours.
Yo, abusuafo, mamu nyinaa good afternoon. Mepa mo kyɛw bebree, mede ma meyɛmfo ya. De nti a mefrɛ mo awie yi ne sɛ, mekrae last year no, ama nti mentumi anyɛ adwuma bio. Nti wɔn de mato universal credit so for a few months nie. Na aka kakraa bi nso, just a few weeks, na me pension aduru hɔnom. Nti mebisa state pension for so wɔn estimate no. Wɔn kyerɛ sɛ bosome sika a menya no mfa ayɛ ketewa bi, which means sɛ mehia pension credit. Yeah, wɔn de ɛho leaflet ehyɛ mu maa me. But say nea ɛha me kakra ne sɛ me claim me workplace pension with Nest. Ɛyɛ kakraa bi, but my concern is say me claim a benya effect bi wɔ amount a menya wɔ me pension anaasɛ mmoa a menya wɔ pension credit no, me nsa bɛka anaa na ɛso bɛte anaasɛ even universal credit a mewɔ so seesei no, sɛ mekɔklemu sika yi a, ɛbɛnya any effect on it anaa. Nti mepamokyɛw moma menhu na is this the right time or is this a megye anaa what do I do because I really need the money. Thank you very much.
Okay. Now, there's a voice note.
Okay, thank you very much. So obviously our sister may be listening for a response. Let me put out a caveat here. This is pension, and we don't come to give pension advice because pension and financial advices are regulated areas within the law. So I'm not here to give pension advice. What I would say is my personal opinion if I were to find myself in this situation.
Okay.
So it is not an advice, it's my opinion as to what I would have done if I found myself in the situation. If I find myself in this situation, my approach will be this. Now, I am on a universal credit, and my universal credit amount is dependent on what I get from my other earnings. If there is a windfall by way of compensation, by way of whatever, in this case, by way of pension lump sum, universal credit will take that into account to decide how much to give me. So I will have to make a decision whether to take this lump sum or convert this lump sum into something else. So that is what will be my approach regarding the universal credit. How much will I be getting? The second one will be that if I'm on the pension credit, the standard pension, so the state pension, or it says the workplace pension. I don't know whether the workplace pension, because we have private pension and also the standard pension within the NI framework. So within the NI framework, as long as you are working and contributing, when you go on pension, you have state pension. But in addition to that, some organizations, depending on the job you do, you pay other pensions. So the employer may be starting pension. Could be local government, it could be this, could be that. So when you go on pension, rather you have two. So this person is asking whether, so comparing, the position is, if I take the lump sum, or should I take the lump sum, and will it affect the pension that I will get every month from the state one? What I wait for is the advice form or note from my the pension provider. So my pension provider will send me advice note because I am due for pension. They will tell me what my options are. And once I receive it, if I understand it, I will make the decision. If I don't understand it, I will go to somebody who has power to give financial advice. And the person will advise me what is best to do. But for now, what I will say to myself is that because I'm already on the universal credit, if I take the lump sum, it will affect how much universal credit I will take. What I will say to myself is that because the state pension and also private pension, maybe other pensions, whether to take the lump sum or not depend on the information that I will receive from the pension provider. So I'll wait for that to come through. Then I'll make a decision whether to read and understand it myself or go to someone who understands and has the power to advise on financial matters to do so.
Okay.
And this is my personal opinion.
Right. Thank you very much. And BWF Solicitors always very responsible and would not want to fall foul of the law because they're leading you to the right side of the law. So I will advise you contact BWF Solicitors for all your legal advice. 07712761884 or 0208 4937340. We have somebody on the line. Hello.
Hello, Pacho, good evening.
Good evening.
Me Pacho, where do you question? I'm my brother about Na
But your mom is so kakra.
okay. My brother, Okofadepa, Ghana, na Eradi Adom, Omo Amano, 90 days. Sa brother Fambra. Na my brother, they worry, so besides a brother and self, so settled. Na no person bisa say, akwa ne ba, no sa akwa ne si decision ne say, because on 90 days also the real boy.
90 days also the room. Okay, lawyer.
Is she on the line?
Yes, she's on that.
Yo, on him I saying,
Patron, I'm more patron pray.
Patron, me who ya pa. Akwala we dia.
Well, yeah, 17 years.
Nti good. Oya akwala mpa. Under 21. Nti oba obedu a obeye application to convert the visa to settled or pre-settled. Because oya akwala nti o maybe can say o pese yema wo ni awo papa wo ni bia na. Oka say yes, our man is settled. Oka say no, your man is pre-settled. Nti aya na waka ni so onka yes. Why?
Oh, okay. Send a lawyer lawyer
Good. So the bad dia, ya ba kai na ya ma wo.
But I was okay, say, or okay, yes.
Aye, patron. Yeah, me that.
And that's the P. Let's pick another one quickly. Hello.
Hello. Hello.
Yes, good evening.
Patron, good evening.
Good evening.
Patron, person me bisa asem kakra.
Mm-hmm.
Asem person me bisa me say, me wo UK hadada. Me kuno nso wa ha. But ye ni eniyoma. But me this is here na mawo. But no half Roby per se, me wo mami you know Ghana 6 and 3. But half Roby no na ebe wari eniyoma. Osi ono person ko adopt me mani you know.
Yeah, what in here me pa. O man on this kakra.
Or say
Nkola 6 and 3.
6 and 3.
Next one.
Only ukunu.
6 and 3 years.
And I ukunu no oko wire for na so wa wire for.
Me ne kuno na wa ha but ye ni eniyoma. Ye ni eniyoma.
Me achas ne.
Me ne me jai. Me ne me kuno na e won krata. Ye be remi awa. But ye ni eniyoma.
Wa worry. But say only ukunu eja. And I ukunu awire for. And no person who fa mama no ba ko di 6 ba ko di 3 if you Ghana ba. Is that not it?
Nti oba na say na nka obe wari no but o kwala ni
Afi ukunu no only ukunu na jai. Nti say o ba ware no so o ware dey nka fa wo. But say ukunu no so timi ware a obetimi the yere for no ebetimi akofa wo manaba. Sa na abuse wo.
ai but no oba na say nkwala ni strength o say nko for mo ba na no ni kuno na wari.
Na so ware ne nya na man.
Oh him ju go so ko adopt wo mo de o ma ba na me bi say bi ya na.
Okay, all right. Yo, the patron, what young fan the say, would you say when you pay Jawari? But now, what can you say? Who will be for? Acquire say, or more eshishaho, empo, or my worry, sanity.
Patron.
Young fan is my worry, or my worry. So, my worry, dear, who can know only the year for free, away, in the year for no, and I say, or your honey.
Oya ni okra indefinite.
Oya hani okuta indefinite.
Patron.
Enti oya hani okuta indefinite owo your friend is saying ukuni abrebumi ono so no ne mane nkwalai so what you say.
Patron.
Nti hwemu oya step mother yes na tie. Nti step mother no ojetum se bokwa kofa ne step children no abadia obey application as if so kofa ono anemba ayeden aba.
Abba.
Because nukunu no eni enyoma ni nukunu ntumi fa na ho de nka nechi. But also trebu say nukunu nie na nukunu ne mba enie. Enti because of the nukunu warranty marriage certificate ni dey dance here say nukunu no the family member no And now nkwalaa no so wo birth certificate any DNA edi adanse say omo papa any saa papa ya wa ware maame we nti saa nyoma mi no ka bo mu a na che say nkwalaa no ene maame no ne papa yin na ye busua baako pacha wajaze nti saa de a ebusua mienu papa ne maame omo kofa omo mba a omo eja won echire e wo Ghana eye papa yi emba na ye maame ne step children. But mamina or your applications of find the stepchildren I then Abba.
Abba.
Aha. Nti se mami no person kwa find the stepchildren Abba because say be a ebruno betuno na be a time kwa. So say cause adoption or person adopting kwalaya. I don't know why you adopt your stepchildren. What just here? And I say and your stepchildren so I just say obi emba mo baby.
Obi ma.
Enti ada okushia on street so am I stranded na wa adopt one na even though obetumi adopt obi a ope but no e be complicated kakra na adoption process no so e kwan wa obesha ase wa ha o de Ghana and I say kro an e manya nkwala no was so
madam hold on lawyer say the former husband okay any nipa washia no so me fan say be a omo together be a omo ahye ho for be 2 or so years omo ti more or less omo aware I mean can is hard
cohabitation
on nyina so nka say me partner ni me dofo ni ne ma ohia omo nti me kwa akofo omo ba rather say be a okofa marriage certificate ni abeche.
I mean Imran say if you are cohabiting it's akin to marriage. But if you are married to, it makes even things easier.
Okay.
Making entry clearance application, a technical compared to entry application. So what hana wo ya na ekwan wo edem. But so the fee abrochire na wo de ba krom ha rules no aya na ya strict. And this one nukunu na wo ho dia. Na say omo wo adwin bi so omo ware a ena omo hwa ase se omo ye arrangement omo de kwakofa nkwala no ato ho mo ware wi a no mo de akofa wo mind you maami we so ho aye nkwala no maami nti papa yi anasa maami aye step mother
so omuti
through papa no they have to there should be some sort of responsibility somewhere even though omo mienu na wo prom ha de but omo nti mbom nti then say maami we epene say ne mba no ebaba ene ne kura abetina so to speak by extension nti asa before we prove say ono maami ne dai ono nkoa na maami no fra no afide ohu ne bio sasa na tie de a ono na ohwe ne kwalai empo nti na meyire fufure yi
me aba la am try no no see ni aba wo
Mpacho me gina so ai.
me be
Mpacho me tie.
dokuna eto ahye eden abene why what does it
Mpacho mate ase.
wo de wo nia se wo maami awo kunia fakola why
Mpacho mate.
na men prepare home kwa kan mo bi antu fufuro bi e maka no gospel wo di so a wo ba bedamase why
Mpacho you mate.
Ti Monday make ready to book appointment.
Mpacho mate.
Thank you. Waso mresa na mpewa sempa. Thank you very much, Navi. Inshallah. 0739208468. Hello.
Hello.
Yeah, good evening.
Good evening. Whether
That
me
is
passion me person come bisa nyame adumo.
Good.
My first time I made a program in
Aya dear kwaba. Next week wa ma ba betwe from field over.
Me a minim dey me mpo. Me phone na me screen who say onam so.
So very good. But you too.
Aye. Me pacho my application they akutuma ma meba or 16 years or Ghana.
Okay.
Na background history ni say meba abuchire no me ware ne papa na me gya akwara no wo ho na me bae na aware ne gu. Ena me na ma struggle ahwe akwara ne saa from day one. My application they akwakotumu. Almost say me the benefit is something, you know. Men qualify. I prove to them me could have special needs child. Me say domestic abuse violence
Victim.
victim patchoy. And I'm a circumstance no me who be ye. Me bano what special needs child, you know. Ne papa seizing a passport. Ɛno nti ama mentumi amfa akora no nto kwan ankɔhwɛ deɛ ɔwɔ fie no. Saa sɛ maka mfimfini a menim deɛ mɛyɛ me ho. Mayɛ application akɔto mu. But finally no, na mente wɔ mo nka. Lawyer ne ka kyerɛ me sɛ because of sɛ meda benefit so no nti no, saa application no check. Ɛdi 2 years ni ɛkɔ 3 years. Mene I think my local MP, Kasaye, and then they got in touch with Home Office. Now, I'm the decision about say maybe you know a bit check. No say maybe will prove a choice say me bano and what's so the coming sa and when you may I'm for proven him. Now say me who prove will cry what's a medical. And I'm just like a lawyer say. Dear be also me jaima oma emresh mom take a decision and I say make me to be free Ghana approve say be a because I really need him.
Okay.
Yeah.
Right. So, Brakoku, so this is a test example of compelling and serious family circumstance that makes the creation of a child from the UK undesirable. Prove that as a sort of banoba anyway. That's it, isn't it?
Yeah.
So how do you prove that your child must be here and it's imminent? Then there should be something that is pushing the child away. And the safe haven should be here where the mother is. What is happening to the child? The mother gave a good reason why she has not been able to visit the child. She's been a victim of domestic violence. And
Which is, by extension, even affecting a collab because they see it possible.
Affecting a colano or wahano, then you're
all Ghana as well. Yeah.
And affecting your organ. Right. We are looking at what the mother wants and what the child wants or needs.
Okay.
I don't think the child expects the mother to do what she wants to do, but the mother must do what the child needs.
Okay.
She would have wished to visit the child. So I was going to ask, 16 years, the child is 16, you've been around for some time, why have you not taken steps? And it's giving reason why she hasn't done so, and that is good reason.
Okay.
So that's ticked off. Why should the child come and why should the decision be made now? What is happening to the child so critical that if we delay the decision, it will affect the child's welfare where the child is? You have to prove it. Is the child going through some trauma? Is there any physical, emotional, or any form of harm to the child? Or is the evidence? Do we have social service involvement or social welfare? Ghana is called social welfare. Do we have social welfare involvement? Do we have police involvement? Do we have anything to show that the child is going through kidnapping experience, the child is going through rape experience, the child is going through gang activity, the child is going through whatever it is, and therefore such social vices the child has involved him or herself in may affect the development, the welfare of the child. And within this month, if the child doesn't move away, we don't know what's going to happen. It's not what she's going to say.
Previously, no one abusing no, and I had a photograph to prove.
Ghana.
Yeah.
Okay.
Photographs to prove say abusing no. Because of that, under ne carer no or one in chain no. And because of that, I didn't go to boarding school. Major letters from boarding school to prove say Obie ni ho Obesha Kran school no na taking in charge. And I have also appointed a primary carer, which happens to be my friend near Madam Fo. And Madam Fo no Astati Ejuma. No, also the letter Eka who say on to me Shakrani because of also the circumstances are changing. And made the document when you now support here, but because of say almost say maybe that benefit is made the no better for decision.
Why not cast out the benefit is so?
Genuine circumstances. But just say
Why not cast out the benefit is so, sir?
Lawyer now me come no or say in the first place okay application file by you shouldn't be on benefit. Cry. But I mean so no many benefits is so for my own decision. It's my circumstances. Because I have a special needs
The
child.
lawyer made a decision before you even apply, isn't it?
Well, maybe the lawyer is trying to make. So, Hanti, but so what rock focusing for through MP.
But you say,
You see, MP abua ma what your letter call to follow up.
me patching na. And Friday na empty no. Almost responded say home office for I responded back. Now almost say mama excuses say and to Kwana war Ukraine most say Ukraine was a for problems no and no delay and
Pacho can be sa when you me pa. Almost say identity delay.
Ukraine to come.
Okay, almost
Can your home office for can you no trade we ask for.
Can't we are seeing that?
But you see, I apologize for the continued delay in concluding Roxanne's application, which we received on the 2nd November 2021. All applications are subject to inquiries with other government departments and international organizations to ensure the statutory requirements have been satisfied. In some instances, these checks have to be pursued at length, and it's unfortunate when, as in Roxanne's case, these checks take longer to carry out than usual. Customers must also be aware that services are further delayed due to our response to the humanitarian crisis arising from the invasion of Ukraine. Unfortunately, this has meant we have had to refocus our resources away from our businesses as usual activity, which has created some delays in the processing applications. Therefore, the public service legal agreement has been amended to 24 weeks. And then they gave further information can be found on blah, blah, blah. And then they gave a website anyway.
Okay.
Nti na mo ka tra wo na ne say nkrofo nya abotare sa.
Yes.
Okay.
And it's but then almost see, although applications can be prioritized over others, this is only considered in the most serious circumstances, such as the need to attend a funeral of a close family member abroad or act as a primary carer to a serious ill relative overseas. And only if such requests are supported by documentary evidence. If Roxanne feels there are reasons to extend his case, he's invited to submit documentary evidence for consideration. Roxanne's application is currently in the final.
I think it's okay. Thank you for sharing the content of your letter with us. And I'm grateful that you didn't disclose personal data in that. So thank you so much for trusting us with your information. So what they are saying to you is that if you think the decision should be made now or to escalate it, you have to show that. And how do you prove it? If you feel that because of what's happening in the life of the child has to come, the school can add a letter, the school or people involved in this child's life can put together. I'm not talking about the person taking care of the child because the person has already given you a letter. But you are telling us that the child is in boarding school, but there's nobody to care
But so
physically for
the
you.
Accra we school, where we are JSS, some of we are JSS this year, no,
So
and the
then
school has
it gets a bit
already
more critical
supported
And
because
this
of
is
that.
your
with
fear.
documents already.
This is our wine time.
Nti sɛ sɛ ɔwɔ madamfo ne nkyɛn sisi a ɔwɔ fie a yɛtwɛn sɛ ɔbɛkɔ secondary school.
And our damn phone say want to me shani be.
Ɔno ankasa no yeah ɔkyerɛ adeɛ ɛna previously no na
So our damn
I
phone no
think
no
ɔyɛ
throw
ne
letter say want to
national
me shani
service
be. And I would come application no. Yes sir.
mpatwae.
Aha.
Nti
Nti
ɔno
nipa
sɛ
no
no
say want to
yɛyi
me
ne
shani
firi
be
fii
no.
nim.
Na wo be asen akọ ne ho bi because school so wa makwan want to me international school mu ho. Yes sir that here.
Yeah.
So more or less, the child is hanging in the balance, and because of that, you can my men cry. They be ana we they be una we ja they be akwara no be pie kro be no ato pun wo ma me hamaji me so mafa o as akwara no cry no because of that, you know, ntumi cry and that if that's the case, then you can put in you can go to another lawyer. Lawyer no be pre-action protocol letter either come home office stating all these reasons,
Okay.
giving the evidence. Now that command was said, they have to take action as one of the reasons for escalating the application decision. Then, just say, we feel say we do a ɔmpɛ ɔmo hu na ɔmo yɛ decision no nkyɛn a ma ɔmo hu ɛna ɔmo ka kyerɛ what you can do and the circumstances that will ɔmo can funeral ɔmo can this ɔmo can that in your case no ɛnyɛ funeral but maybe that akwadaa no nea ɛkɔ so na abere bɔ mu nti you have to take action nti the new lawyer will do a pre-action protocol letter to the Home Office requesting that or making a request to the Home Office stating that there has been undue delay. Acknowledging saying you might cause no more delay. However, in this case, the delay should not affect the decision because it will affect Apalano development and growth and everything. Then they will push the case. And to make an assistant lawyer, you don't have to stick to one lawyer if your matter is not going.
Oh, okay. Okay.
But yes, I mean, let me put in this. A new lawyer may again ask for a new what? Fee. So I want you to think, say, because we make another lawyer want to
It could be fair.
inquire now, almost member maba, they will of course start your application as a new thing, not new application, but continue from where they left off. So if you can afford that's fine. So that's something you can consider. If you can afford, then I would say, sir, just leave it and pray, sir, at least. But me, I consider what you know as one of the priority cases. Why?
Because my lawyer no may forward the way in a man no. On can be beer bimba or say one notice said in Saka like noted, but then one can't be beyond me. And I
So
let
I catch you
no
something to me,
say
and
yeah, but home office for say you will prove beer. So as a lawyer, no, at least first
yeah,
I'll bet
but
me communicate with me to see say if there's something
yeah,
I
I
can add
understand
to
you.
my
So it
application.
is what you want to do now. You can wait for your lawyer to finish the case for you, or you can move it to another place for it to be expedited by way of letters to the Home Office. But again, it depends on your strength, your ability to afford
Okay.
or incur extra cost. However, it's a matter of
Okay.
benefit and the cost. If the benefit is more than the cost that you are seeking to incur, then sometimes it's better to incur extra cost to get the benefit you want immediately. But lawyer no dey no pa cha ne say ade no kra wo dey kwano kra no kan say yi na ye dey akon so a wo hamaji. So what just here?
Yeah.
So he may not really bother too much. So you have a choice what you want to do under circumstance. Why?
I'll show you.
All
I'll
right.
show you me that's the brave. That's it. Bye.
Okay.
Bye.
Okay. Hello? Oh, okay. There's the text here that, okay, I think we dealt with that in the previous, the one with the 6 and the 3.
All right.
Yeah,
Okay, yeah, the same person.
yeah. Now I am torn between devil and the deep blue sea. I'm running out of time. I've got so many text messages. I've got so many calls coming through.
I mean, I think so. Let's maybe do a couple of. Can do 10. We can get them within 10 minutes.
Okay. Okay, let me take this text from an A. Well, what line is just hold on for me. Let me treat this text, and I'll come back to you. I'll say Amma and her partner Kofi have been married for 5 years. Kofi had a daughter before marrying. The daughter was abandoned by her mother from the age of 2, which meant Kofi became the sole carer of the child since then. The biological mother has made no contact with the child since. Amma now wants to apply to come to the UK through the skilled worker route with her partner and the child. Upon documents requested from her, for a lawyer to make her application successful, a DNA was requested, and the outcome was the presumed biological father, Kofi, was not the biological father to the now 12-year-old child. Please advise on what they can do to prove the relation between the child and the presumed father with no access to communication with any of the child's biological family members. Is adoption the only way forward, or any other option to enable them to travel with the child? Well, how about friend to I don't know our relationship or
So-
DNA. DNA, yeah, yes, and requested DNA for prove and also
So let me unpick the facts. So Amma is the one doing the skilled worker thing.
yeah,
All right. Who's Kofi? Kofi Amma Kunumebua.
yeah.
All right. Kofi is traveling with Amma, or is Kofi the one traveling with Amma?
Kofi traveling in Amman, but they want to bring
So good. So Kofi is the one traveling. My understanding is that Kofi is Amma's, is the daughter's father. This daughter's father. Good. Kofi is traveling with Amma as skilled worker independent. Want to bring the child.
The child.
Because the child is Kofi's child, presumably. The child may not be Amma's child, but it's Kofi's child. It turns out that the child is not Kofi's child.
but we're here now for 12 years.
Well, we're talking about the child, the father of the child. So he cannot say that this is my child based on the DNA. Kofi may have the child's birth certificate
With his name on it.
proving that he is the father. Presumably, he has been the father until this happened. So there are two pieces of evidence: birth certificate and DNA. One proves 100%, the other does not prove 100%. Kofi has a choice which one to rely on.
Okay.
Then the people will make a choice whether to follow through what Kofi has brought to us or not.
Okay.
Kofi, under the circumstances, can only present the first evidence of paternity, which is the birth certificate of the daughter.
Okay.
There's no law or rule that bring DNA. I told you earlier on that the prima facie evidence of fatherhood and motherhood is birth certificate of the child. By extension, we say DNA to prove that birth certificate is correct. But you don't have to present both. You have a choice to go with the DNA or go with the birth certificate, and let them make a decision. You know that if you go with the DNA, the decision will not be what you want. Go with the birth certificate, because that one, you don't know what decision you come up with. The other one, you know the decision.
Yeah.
This one, you don't know. If anything, they will ask you, prove that it's correct birth certificate. You don't issue birth certificate. It is the government that issues birth certificate. So if anything, you refer them to the government that issues birth certificate to prove that it is correct or not correct. So he has a choice to use the birth certificate.
Okay. All right. We have only 5 minutes. In 5 minutes, those of you on BW Radio will go off, and there will be new broadcast. We'll try as much as possible to finish in the 5 minutes, so you do lose out anything, and you can also benefit from the news as well. So go on to the line 0739920848. Hello.
Hello. Patrol me beside Snappy. The ambassador me beside it. Na me name really kata. Ena me ba di body a British passport. And then just in yes, in 2.5 years. But you can my class.
Meaning open tembat nyabuche. Also one way munin krata, right?
Yeah, in krata.
No munin krata. Okay.
Yeah, na yembato. Yebani di 10 years now. And then yebani di 10 years British passport and then 2.5 years. But it's me matna coma 20 years. And I'm it when I'm may end more than 18,500. But I mean, besides I send me renew in September. But the same you can make match switch to match switching now to 5-year route nana.
I know I did 20 years for her, long students. But
Maybe
with
20 years
a
for her.
British child, so
I'm not
any other day. Okay.
Is he on?
Yeah, go.
Are you living with your spouse and the child?
Pacho,
If you are living with a spouse and a child, even though under normal circumstances you can switch, they take a decision that no, you can't. You have to stay on the 10.
Okay.
So they are more or less saying that if you are not living with the wife, the spouse, it would have been easier under direct access. But coming together as a family, switching is harder. So most applications that we've made with switching, they conclude that no, back on the 10-year route because you are living together as a family, and therefore you cannot switch out. So if at any point you are living alone, then per their rules, you can switch because you then go as a direct access father, not as spouse together, making application based on the child. Sometimes they get the rules mixed up themselves, but it is what it is.
Anyway, I use BWF, so I'll come. I know there's going to be a way. Thank you so much.
Where there's a will, there's a way. Thank you very much for your contribution. Boss, enjoy your weekend. God bless. Nothing less, no stress. I would say there's a point where we will be drawing curtains down on the program. Tradition demands. My tradition on this program as a demand. I'll get lawyer Charles Osman to do his summary, and I will do my closing.
Right. So it's been a pleasure once more joining you here on the Community and the Law program. Today, we looked at bringing a child from the UK, and we echoed the fact that the application to bring a child has two gateways, EU gateway and immigration rule gateway. The EU gateway is simpler because you don't need to prove anything. All you need to prove is the fact that the person is your child. And if the child is under 21 or 21 years, you don't really need anything else. But if the child is over 21 years, you need to show that you take care of them. However, if it's under the immigration Appendix FM provision, you need to show more than just saying that this is your child. We agree, I understood that child means under 18 years, parent means biological parent or adopted parent. Adoption means going through the court to get a court order. We also concluded that in addition to meeting everything, you have to show sole responsibility, and you have to show that there is compelling and exceptional family circumstance that makes the exclusion of the child undesirable. Therefore, it's a high threshold application. It's always important that you treat it as a project to be able to get it right from the outset. If both parents are in the UK, then you don't need to prove sole responsibility, provided the parents are living together. However, if they are not living together, then you still have to show that even though they are both in the UK, the other parent does not really play much role in the life of the child. And that is why this parent is bringing the child. What has been the trend is that they always use sole responsibility and serious and compelling family circumstance to refuse the application. Therefore, when you are making such application, please take your time to get it right, so that even if it has to go to court, they will draw the application before hearing starts. Thank you for making time. I believe that this has been useful for you and for your family and friends. Join us again next week and during the week as we come on the show. Thank you.
Definitely, it's been very useful. It's been very, 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 very good. It's been worth a while. And I believe that we will make time, as lawyer said, the invitation is extended to you. So Same time next week we'll be on. Those of you that had your questions coming through and calls coming through that we didn't have time enough to pick up, forgive us. We will make sure that all those text messages and the other things will be added to our subsequent program. So please forgive us. Time and tide, they say, waits for no man. Kind of exceptions. Those on BW Radio now, it's news time. You've tuned in there, and those of you here, we're saying our thank yous and our byes. I want to say thank you very much to Charles Asma for his kindness and the grace to even come and share knowledge with us. It's all in the service of the community. And thank you once again to BWF Solicitors, our trusted partners when it comes to the law. BWF Solicitors is there for you to help you understand what the law says, how to go along with the law, and how to make all your applications, especially your immigration issues here, immigration and nationality issues here in the UK. Professor Ade produced the show and, of course, directed the studio for us. Sheila Ankara and Padwell Dudu, thank you so very much. And to all the big family members of BWF Solicitors, I salute all of you and I say God be with you. And to you out there, if you have not stayed with me, it wouldn't have been worth my while. Thank you so very much. I'll be with you same time next week. Until then, be good.
Jesus, you're my everything, yeah. My everything is you, Lord. Yeah. Oh, 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 oh. Everybody say, ah. Say, how can I express my gratitude for all the many things you've done for me? Words